Article 11. Accountability of Public Officers. Section 1. Public office is a public trust. Public officers and employees must, at all times, be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. The public officers and employees, as a policy of the state, must at all times promote a high standard of ethics in public service. Public office is a position of services. It is also called public trust because the government has trusted their officers and employees with their positions. Elements of public office. It must be created by law or ordinance authorized by law. The public office is created either by the Constitution, the legislature, or a municipality or other body through authority granted by the legislature. It must possess sovereign functions of government to be exercised for public interest. The public office possess a portion of the sovereign power of the government and they will exercise it for the benefit of the public. Next, the functions must be defined expressly or impliedly by law. The powers granted and the duties discharged to the public office must be defined directly or impliedly by the legislature or through legislative authority. Next, the functions must be exercised by an officer directly under the control of law, not under that of a superior officer unless they are functions conferred by law upon inferior officers, who by law are under control of a superior. It says that the power and duties given to the public office must be independent, performed independently without the control of superior power other than the law, unless those powers authorized by the law. Next, it must have some permanency or continuity, not temporary or occasional. The public office must be permanent and continues to exist and not just be temporary or occasional. Classification of public officers: executive, legislative, and judicial. This is when public offices and public officers on which their functions pertains to what department of government they are in. Discretionary or ministerial officers. In discretionary, if the law imposes a duty upon a public officer, it gives him the right to decide how or when the duty shall be performed, while a ministerial officer, defined as one whose duty it is to execute the mandates lawfully issued by his superiors. Civil or military. Nature of functions. Any person who is appointed by the government and who holds executive, legislative, or judicial authority is called a civil officer. While military officer, it is any person in the armed services who holds a position of authority or command. Officers de jure or de facto. An officer de jure is a person who is legally appointed to exercise the functions of an office. It is a person who will be appointed as an officer de jure if she or he fulfills the required qualification to hold the office, while an officer de facto is the one who has the reputation or appearance of being the officer he assumes to be but who, in fact, under the law, has no right or title to the office he assumes to hold. Next, national, provincial, and municipal officials. This is where the public bodies serve. Eligibility and qualification has two senses. First, it may refer to endowments, qualities, or attributes which make an individual eligible for public office. Eligibility, which is the term usually used in reference to the civil service law. It refers to the endowment, the natural capacity, power, or ability of a person, requirement, accomplishment that fits one for a public office. Second, it may refer to an act entering into performance of functions of public office. Qualification generally refers to the endowment act which a person must do before he can occupy a public office. Section 2. The President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on the impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes or betrayal of public trust. All other public officers and employees may be removed from office as provided by law, not by impeachment. The impeachable officials are the President, Vice President, Chief Justice and Associate Justices of the Supreme Court, Chairmen and members of the Constitutional Commissions, and the Ombudsman. The grounds for impeachment. Number 1. Culpable violation of the Constitution. The willing to violate the Constitution or breaching the Constitution. Number 2. Treason. It is giving alliances other than the Republic of the Philippines. Number 3. Bribery. The revised penal code defines bribery in two forms. Letter A, direct bribery. Letter B, indirect bribery. Direct bribery. The offender agrees to perform or performs an act or refrains from doing something because of the gift or promise. In indirect bribery naman, it is not necessary that the officer should do any particular act or even promise to do an act because it is enough that he accept gifts offered to him by reason of his office. Number 4. Graft and corruption, which a public official found to have acquired, whether in his name or in the name of other person, an amount of property and money manifestly out of his proportion to his salary. Number 5. Betrayal of public trust or other high crimes, which are offenses like treason and bribery. They are so serious and enormous in nature because they strike at the very life or the orderly workings of the government. Section 3, Paragraph 1. The House of Representatives shall have the exclusive power to initiate all cases of impeachment. Exclusive power means the reserved power given to them by the state. Paragraph 2. A verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution or endorsement by any member thereof, which shall be included in the order of business within 10 session days, and referred to the proper committee within 3 session days thereafter. The committee, after hearing and by a majority votes of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. The resolution shall be calendared for consideration by the House within 10 session days from receipt thereof. Paragraph 3. A vote of at least one-third of all the members of the House shall be necessary either to affirm a favorable resolution with the articles of impeachment of the committee or overrides its contrary resolution. The vote of each member shall be recorded. Paragraph 4. In case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. The paragraph 2, 3, and 4 of Section 3 contains the impeachment procedures. The impeachment procedures are: first, the filing of verified complaint. The complaint can be filed by any member of the House of Representatives, any citizen with an endorsement of a member of the House of Representatives, or by at least one-third of all the members of the House of Representatives. Second, inclusion of complaint in the order of business with 10 session days. The complaint must A. Has substance. It is what the complaint all about. B. Sufficient in form. It must be verified that it requires that the complainant has personal knowledge or that the allegations made are supported by authentic documents. C. Sufficient in grounds. It is the reason to complain sufficient in law. D. The probable cause in the complaint. It is the reasonable belief based on the possession of facts that a person can be sued or arrested and prosecuted. Third, referral to proper committee within 3 session days thereafter. Fourth, submission of committee report to the House together with corresponding resolution. Here, there should be a hearing, there should be a majority vote of the members, and the report should be submitted within 60 days from referral after hearing and by majority vote of all its members. Fifth, calendaring of resolution for consideration by the House. It should be done within 10 session days from receipt thereof. 6. In order to affirm a favorable resolution with the articles of impeachment of the committee or to override or change its contrary resolution, it needs the vote of at least 1/3 of all members of the House. And lastly, if the verified complaint or resolution of impeachment was filed by at least 1/3 of all the members of the House, it shall constitute the articles of impeachment. Trial in the Senate shall proceed. The House will appoint prosecutors who may or may not be members of the House. They will be headed by the Chairman of House Committee on Justice. But if the vote fails in any part of the procedure, the official accused cannot be filed for impeachment for 1 calendar year. Limitations on impeachment. Paragraph 5. No impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. It said that the accused official cannot be impeached for more than once in a year. Paragraph 6. The Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senators shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. Trial and decision in impeachment proceedings. First, the Senate has the sole power to try and decide all cases of impeachment. Second, for this purpose, the senators shall be under oath or affirmation. Third, when the President of the Philippines is on trial, the Chief Justice of the Supreme Court presides. However, he or she will not vote. Fourth, a decision of conviction must be concurred in at least 2/3 of all the members of the Senate. Paragraph 7. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold any office under the Republic of the Philippines. But the party convicted shall nevertheless be liable and subject to prosecution, trial, and punishment according to law. Paragraph 8. The Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. The effects of impeachment. First, removal from office. Second, the disqualification to hold any office under the Republic of the Philippines. And third, the party convicted shall be liable and subject to prosecution, trial, and punishment according to law. Section 4. The present anti-graft court, known as the Sandigan Bayan, shall continue to function and exercise its jurisdiction as now or hereafter may be provided by law. Composition of Sandigan Bayan. Sandigan Bayan is a special court, possessing all the inherent powers of a court of justice, created and composed of a presiding judge and 8 associate judges who are appointed by the President, and subject to the same inhibitions and disqualifications as judges of courts of first instance. Courts of first instance are the courts in which a case is first heard.
Jurisdiction of Sandigan Bayan. The National Assembly shall create a special court to be known as Sandigan Bayan, which shall have jurisdiction over criminal and civil cases involving graft and corrupt practices and such other offenses committed by public officers and employees, including those in government-owned or controlled corporation in relation to their office as may be determined by law. The Sandigan Bayan shall have original and exclusive jurisdiction to try and decide violation of Republic Act 3019 as amended, otherwise known as the Anti-Graft and Corrupt Practices Act, Republic Act No. 137, crimes committed by public officers or employees, including those employed in government-owned or controlled corporation, embraced in the Title VII of the Revised Penal Code. Other crimes or offenses committed by public officers or employees, including those employed in government-owned or controlled corporation in relation to their office, provided that in case private individuals are accused as principals, accomplices, or accessories in the commission of the crimes herein above mentioned, they shall have been tried jointly with the public officers or employees concerned. Exception from the foregoing provision during the period of material law are criminal cases against officers and members of the armed forces of the Philippines and all other who fall under the exclusive jurisdiction of the military tribunal. Proceedings of Sandigan Bayan. Proceeding against constitutional officer, votes are required. All cases involving constitutional officers shall be heard and decided by the Sandigan Bayan en banc, provided that when an unconstitutional officer or employee or private individual is charged or sued jointly with a constitutional officer under Section 4, they shall all be tried jointly by the Sandigan Bayan en banc. All other cases may be tried and decided by a division. Section 5. There is hereby created independent office of the Ombudsman composed of the Ombudsman to be known as Tanod Bayan. One overall deputy, at least one deputy each for Luzon, Visayas, and Mindanao. A separate deputy for the military establishment may be likewise be appointed. Office of the Ombudsman. Samuel R. Martirez is the Ombudsman of the Philippines. Overall Deputy Ombudsman is Warren Leong, appointed by President Duterte. Deputy Ombudsman for Luzon is Cornelio Sumido, appointed by President Duterte. Deputy Ombudsman for Visayas is Paul Elmer Clemente, appointed by former President Benigno Aquino III. Deputy Ombudsman for Mindanao is up for appointment by President. Section 6. The official and employees of the Office of the Ombudsman, other than the deputies, shall be appointed by the Ombudsman according to the Civil Service Law. The general purpose of this section is to ensure and promote the constitutional mandates regarding appointments only according to the merit and fitness and provide within the public service a progressive system of personal administration to ensure the maintenance of the honest, efficient, progressive, and cautious civil service in the Philippines. Section 7. The existing Tanod Bayan shall hereafter may be known as the Office of the Special Prosecutor. It shall continue to function and exercise its power as now or hereafter may be provided by law, except those conferred on the Office of the Ombudsman created under this Constitution. Under the 1987 Constitution, the existing Tanod Bayan became the Office of the Special Prosecutor. Prosecutor is a person, especially a public official, who institute legal proceedings against someone. Powers. It will continue to function and exercise its power as now or hereafter may be provided by law. Exemption. Power conferred on the Office of the Ombudsman. The Office of the Special Prosecutor is subordinate to and acts under the orders of the Ombudsman. Section 8. The Ombudsman and his deputies shall be natural-born citizens of the Philippines and at the time of their appointment at least 40 years old, of recognized probity and independence, and members of the Philippine Bar and must not have been candidates for any elective office in the immediately preceding election. The Ombudsman must have for 10 years or more been judged or engaged in practice of law in the Philippines. Section 9. The Ombudsman and his deputies shall be appointed by the President from a list at least 6 nominees prepared by Judicial and Bar Council, and from a list of 3 nominees for every vacancy thereafter. Such appointments shall require no confirmation. All vacancies shall be filed within 3 months after they occur. Why we don't check it one by one like when the President chooses secretaries for the department? The thing is, these nominees are already qualified since they were prepared by the Judicial and Bar Council themselves. Section 10. The Ombudsman and his deputies shall have the rank of chairman and members, respectively, of the Constitution Commission, and they shall not be qualified to run for any office in the election immediately succeeding their term of office. This section is very straightforward, but if you must know, the COMELEC or the Commission on Election, the CSC or the Civil Service Commission, and COA or Commission and Audit make up the Constitutional Commission, each with their own unique function. Section 11. The Ombudsman and his deputies shall serve for a term of 7 years without reappointment. They shall not be qualified to run for any office in the election immediately succeeding their cessation from office. Term of office. The Ombudsman and his deputies, including the Special Prosecutor, shall serve for a term of 7 years without reappointment.
Removal. Filling of vacancy. Number 1. In accordance with the provision of Article 11, the Constitution, the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of the public trust. Little while ago, Mr. Igano, he has already done to discuss it on Section 2, Article 11. The example of the impeachable officers, and we already know, not only with the President, Vice President, Chief Justice, and Associate Justice of the Supreme Court, Chairman and members of the Constitutional Commission, but also the Ombudsman are liable to impeachment. Way back during the presidency of Gloria Macapagal Arroyo, the Philippine Ombudsman Merceditas Gutierrez was impeached by the House of the Representatives on charges of the office alleged under the performance and failure to act several cases. Number 2. A deputy or special prosecutor may be removed from office by the President or any of the grounds provide for the removal of the Ombudsman and after due process. Why due process is important? Due process is important because it is a legal requirement that requires the state to respect all the legal rights owed to a person. Due process is a balance of power of the state and protects the individual person from the power of the state. And let's move on to number 3 and 4. Number 3. In the case of vacancy, in the office of the Ombudsman, due to death, resignation, removal, or permanent disability of the incumbent Ombudsman, the overall deputy shall serve as acting Ombudsman in a concurrent capacity until a new Ombudsman shall have been appointed for a full term. In case of overall deputy cannot assume the role of the acting Ombudsman, the President may designate any of the deputies or the special prosecutor as acting Ombudsman. And the number 4. In the case of temporary absence or disability of the Ombudsman, the deputy shall perform the duties of the Ombudsman until the Ombudsman return or is able to perform his duties. Why is it necessary to replace the Ombudsman immediately when it's incapable of the performing his duties? Because the role of Ombudsman is to ensure that all public officials perform their duties with justice, honesty, and public responsibility. The Ombudsman became a unique instrument to represent the interests of the citizen, protect the basic human rights, and improve quality of the public administration. Therefore, he must be replaced immediately when he is incapable of performing his job. Section 12. The Ombudsman and his deputies, as protectors of the people, shall act promptly on complaints filed in any form or manner against public officials or any employees of the government or any subdivision agency or instrumentality thereof, including government-owned or controlled corporations, and shall, in appropriate cases, notify the complaints of the action taken and the result thereof. Now, this is somewhat related into section 13. It's quite long and I'm going to skip it, move past, and I try to explain all. Section 13. The office of the Ombudsman shall have following. powers, function, and duties. Powers, functions, and duties of the Office of the Ombudsman. Number 1. Investigate on its own or own complaint by any person, any act or omission of any public officials, employee, office, or agency when such act or omission appears to be illegal, unjust, improper, or inefficient. Number 2. Direct. Upon complaints or at its own instance, any public official or employees of the government or any subdivision, agencies, or instrumentality thereof, as well as any government-owned control corporation with original charter, to perform and expedite any act of the duty required by law, or to stop, prevent, and correct any abuse of impropriety in the performance of duties. Number 3. Direct. Direct the officer concerned to take the appropriate action against public officials or employee at fault, and recommend his removal, suspension, demotion, fine, censure, or prosecution, and ensure compliance therewith. Number 4. The officer direct the officer concerned in any appropriate cases and subject to such limitation as may be provided by law to furnish it with copies of documents relating to contract or transaction entered into by office involving the disbursement or use public funds of the properties, and report any irregularity to Commission on Audit for appropriate action. Number 5. Request any government agencies for assistance and information necessary in the discharge of its responsibilities and to examine if necessary pertinent record and document. Number 6. Public matters covered by its investigation when circumstances so warrant and with due process. Number 7. Determine the cause of inefficiency, red tape, mismanagement, fraud, and corruption in the government and make recommendation for their elimination and the observance of high standards of ethics and efficiency. Number 8. Promulgate its rules of procedures and exercise such other powers or perform such function or duties as may be provided by law. When the Office of Ombudsman decided to do investigation by themselves, is there a trigger? Yes, there is usually is. Since the Ombudsman has investigatory power, he can its own with a tip from letters, phone calls, or oral complaints. This is important because that it means the Ombudsman is available to a public and we can reach everywhere, even from jail and hospital, although the Ombudsman can be refused investigate.
Section 14. The Office of Ombudsman shall enjoy fiscal autonomy. Its approved annual appropriations shall be automatically and regularly released. What is the fiscal autonomy means? Fiscal autonomy means freedom from outside control, meaning an institution has full flexibility to allocate its or utilize its money and dispatch needs that it requires. Section 15. The right of the state to recover properties unlawfully acquired by public official or employees from their nominees or transferees shall not be barred by prescriptions, laches, or estoppels. What prescriptions, laches, and estoppels means? Prescriptions is the process of making claim to do something by long use and enjoyment. Laches is the neglect to assert the right or claim that together with lapse of the time and other circumstances, prejudice, and adverse party. Estoppel is a legal bar which precludes someone from denying the truth of the fact which has been determined in an official proceeding or by an authoritative body. Recovery of ill-gotten wealth. Number 1. The right of the state to recover properties unlawfully acquired by public officials and employees from them or from their nominees or transferees shall not be barred by prescriptions, latches, or estoppels. Number 2. There is the right to prosecute criminally. This is official and employees may be prescribed. Based on the Republic Act Number 7080, an act of defining and penalizing the crime of plunder. On Section 1, Paragraph 4. Ill-gotten wealth means any asset, property, business enterprise, or materials, possession of any person within the purview of Section 2, thereof acquired by their directly or indirectly through dummies, nominees, agent, subordinates, and or business associates by any combination of series of the following means of similar scheme. Tumpo sa Section 2, definition of crime of plunder, penalties. Pero kung gusto nyo pong malaman kung ano yung pinakamagandang example po dito, ay walang iba kundi yung pamilyang Marcos. The Presidential Commission on Good Government or PCGG tasked to recover the ill-gotten wealth of dictator Ferdinand Marcos and his family and his cronies, and the PCGG has recovered over the last 30 years at least 170 billion in cash, despite working on other overall budget of 2.9 billion over the same period. And we see what happened to the family of Marcos. It's just an example that the authorities are doing something to prosecute the offenders.
Section 16. No loan, guarantee, or other form of financial accommodation for any business purpose may be granted, directly or indirectly, by any government-owned or controlled bank or financial institution to the President, the Vice President, the members of the Cabinet, the Congress, the Supreme Court, and the Constitutional Commissions, the Ombudsman, or to any firm or entity in which they have controlling interest during their tenure, which means the President, Vice President, the members of the Cabinet, the Congress, the Supreme Court, the Constitutional Commissions, Ombudsman, and any firm or entity which they have controlling interests are prohibited from obtaining loans, guarantees, and any forms of financial accommodation for their business through government-owned banks or financial institutions, but they can still get a loan as long as that it is not used for their own business and financial growth. Prohibition on certain financial transactions. This prohibition applies to number 1, President, number 2, Vice President, number 3, members of the Cabinet, number 4, members of Congress, number 5, members of Supreme Court, number 6, members of Constitutional Commissions, number 7, Ombudsman, number 8, any firm or entity in which they have controlling interests. When prohibition applies during their tenure. Scope of prohibition. Number 1, the above-mentioned officials cannot obtain directly or indirectly for business purposes such as loans, guarantees, other forms of financial accommodation from government-owned or controlled banks. Example is Home Development Mutual Fund or Pag-ibig Fund and Land Center of the Philippines. While government-owned or controlled financial institutions, for example, is Bangko Sentral ng Pilipinas and Land Bank of the Philippines. Number 2, if the loan is not for business purpose, example, housing loan, the prohibition does not apply. Section 17. A public officer or employees shall, upon assumption of office and as often thereafter as may be required by law, submit a declaration under oath of his asset, liabilities, and net worth. In the case of the President, Vice President, the members of the Cabinet, the Congress, the Supreme Court, and the Constitutional Commissions and other constitutional offices and officers of the Armed Forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law, which means to show transparency, to avoid corruption, and to gain the public trust. Giving the public the view of their sole end makes the public aware so corruption can be mitigated and easily spotted by the public, especially when there's a sudden spike on their sole end, and they must explain their phenomenal growth in wealth during their incumbency. When declaration shall be disclosed to the public. These declarations shall be disclosed to the public in a manner provided by law in the case of number 1. President, number 2. Vice President, number 3. Members of the Cabinet, number 4. Members of Congress, number 5. Justices of the Supreme Court, number 6. Members of Constitutional Commissions, number 7. Other constitutional offices, number 8. Officers of the Armed Forces with general or flag rank.
17. Public officer or employees shall, upon assumption of office and as often thereafter as may be required by law, submit a declaration under oath of his asset, liabilities, and net worth. In the case of the President, Vice President, the members of the Cabinet, the Congress, the Supreme Court, and the Constitutional Commissions and other constitutional offices and officers of the Armed Forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law.
Section 18. Public officers and employees owe the states and this Constitution allegiance at all times. When any public officer or employee who seeks to change his citizenship or acquire the status of an immigrant of another country during his tenure shall be dealt with by law. Meaning, at all times, all designated public servants and officers owe allegiance to the Republic of the Philippines State and Constitution. Since one of the requirements for the role is that an incumbent should be a Filipino citizen. If he or she changes citizenship or obtains immigrant status in another country, he or she will lose his or her position. For an incumbent, loyalty to the country and to the office is a must. Allegiance of public officers and employees. Change in citizenship or immigrant status. Number 1. Incumbent public officers and employees who seek either change his citizenship or acquire immigrant status in another country should be dealt with by law. Number 2. Philippine citizenship is one of the qualifications to the office. The loss of such citizenship means the loss of the office by the incumbent, which means when an incumbent changes his citizenship or immigrates to another country during his or her term, he or she will face legal consequences for violating the oath of allegiance to the Republic of the Philippines. Because Philippine citizenship is one of the qualifications for an incumbent public officer. Failing to meet this requirement will result in the loss of his office. Number 3. The Election Code provides the rules with respect to non-incumbents, namely persons running for elective offices. The code provides that permanent residents of or immigrant to a foreign country cannot file certificates of candidacy unless they expressly waive their status as such. This renunciation must be some other than and prior to the filing of the certificate of candidacy, which means non-Philippine citizens as well as those who have a permanent residency in or are immigrants to another country are prohibited from running for elective positions in the Philippines, according to the Election Code. If a candidate holds dual citizenship, he or she must renounce it and declare it on his or her Certificate of Candidacy or COC.